Hi, I'm Anika Ranchhod, solicitor at Williamson Barwick, an employment and industrial law firm. As an employer, you are responsible for ensuring that your employees behave professionally and respectfully. Unfortunately, there will be times when an employee steps out of line and engages in misconduct. If not handled properly, this can lead to legal trouble for your organisation. So, how can you deal with employee misconduct without getting into legal strife? Well, it's a bit of a tricky area for employers to navigate and address. So, in today's video, I'm going to discuss the difference between misconduct and serious misconduct, the legal risks for employers if a proper process is not followed when dealing with employee misconduct, and provide some strategies for employers to ensure a fair and lawful process is followed. Alright, let's start with general or simple misconduct, which is essentially when an employee behaves in a manner that the employer considers unacceptable or inappropriate. So, for example, coming to work late may be regarded as misconduct, or if you're absent from work without authorization, that might also be considered misconduct. Other examples include unwelcome behavior toward another employee or the use of inappropriate language in the workplace, but it all depends on the degree of the conduct. So, if an employee swears at their manager in the heat of the moment, and that is uncharacteristic, that's probably going to be a simple case of misconduct. Or if an employee failed or refused to comply with a lawful direction, such as carrying out a non-critical work task, that could also be a simple case of misconduct. Although these examples of employee misconduct won't justify dismissal, it's still misconduct and should be addressed to avoid repeats of the behaviour. So, we advise that an employer should address any concerns about an employee's conduct and behavioural issues at the time they occur and take appropriate action. Unfortunately, there's no single rule that applies to what appropriate disciplinary action is. Assessing an employee's conduct to determine the appropriate course of action is a challenging exercise, and it should always be considered on a case-by-case basis. But, depending on the circumstances, an employer can take appropriate action for simple acts of misconduct by counselling the employee, providing a verbal warning, or issuing a written warning. And depending on various factors, it may also be important to allow the employee to respond to the allegations of misconduct before taking disciplinary action. Often, employee misconduct is not isolated. In circumstances of repeated misconduct or a pattern of poor behaviour, tougher consequences such as a final written warning may be warranted, or potentially even dismissal, subject to a fair process being followed. But if you decide not to go this route and rather issue a formal warning, you should provide any necessary training to the employee so that your expectations are made clear. This might include refresher training on the employer's code of conduct. Now, let's move on to serious misconduct. According to Fair Work regulations, serious misconduct has its ordinary meaning. This means that you can rely on general law for guidance as to its meaning, and you can rely on specific misconduct that is outlined in the definition in the Fair Work regulations. General law states that an act of serious misconduct is so serious that it would justify the termination of the employment contract without notice or payment in lieu of notice. Many employment agreements specify what the parties regard as serious misconduct. Under the Fair Work regulations, serious misconduct is where an employee deliberately behaves in a way that is inconsistent with their continuing employment and causes serious and imminent risk to the health and safety of another person or the reputation, viability and profitability of their employer's business. For example, this may include theft, fraud, assault, sexual harassment, being intoxicated at work, or refusing to carry out a lawful and reasonable instruction consistent with the employee's employment contract. Often, it is necessary to conduct a factual investigation to determine whether the employee has engaged in serious misconduct before taking disciplinary action. According to the Fair Work Act, an employer must provide notice of termination or payment instead of notice, but there are some exceptions to this rule. One would be where employment is terminated due to serious misconduct. So, This means that if the factual investigation has led to identifying serious misconduct, an employer has grounds to summarily dismiss an employee. In other words, the employment contract can be terminated immediately with no notice or payment in lieu of notice. So those are the differences between simple and serious misconduct. Now, it is important to ensure that you follow a proper process before deciding whether to dismiss an employee. This is the right thing to do for the person concerned and their mental health, but it also helps manage the risk of a legal claim. The main legal risk an employer faces if they do not follow a procedural or substantively fair process is an unfair dismissal application. In an unfair dismissal application, the employer risks the Commission ordering an employee to be reinstated or the payment of compensation to the employee. Other legal risks include that an employee could make a general protections application, a breach of contract claim, or a discrimination claim. Litigation is costly, distracting, and time-consuming. It can also be damaging to the employer's reputation, especially if adverse findings are made by the Fair Work Commission or a court. So, to avoid this, I want to share a few strategies you should consider employing as part of your disciplinary process. Be aware that an employer who dismisses an employee due to serious misconduct has a heavy burden because the employer bears the onus to prove that the misconduct has occurred in the Commission or the court. This means you have to establish a valid reason for the dismissal, such as serious misconduct. So, in cases of serious misconduct, we recommend that employers afford the employee procedural fairness by: number 1, following the organisation's policies and procedures that apply to disciplinary matters. Number 2, ensuring the precise allegations are explained to the employee with enough information so they are able to understand the allegation and respond. This may also mean you need to show them relevant documents or even CCTV footage that may be relevant to the allegation. Number 3, allowing the employee to respond. This might be verbally or in writing or both. Number 4, considering the employee's response before making a decision. Number 5, considering any other matters that may be relevant and allowing the employee to address other matters such as past service, length of service, the likelihood of repeating the misconduct, and the effect of dismissal on the person. And number 6, not unreasonably refusing to allow a support person present at disciplinary meetings. If your organisation does not already have a performance and misconduct policy in place, we can draft and assist with implementing the policy. A performance and misconduct policy can serve the dual purpose of encouraging improvement in the standard of the employee's performance and conduct, and guiding the organisation to ensure that a fair procedure is followed and sound decisions are made. We recommend seeking legal advice in circumstances where there are contentious allegations of misconduct or serious misconduct to ensure that the correct process is followed. We have guided many employers through workplace investigations, disciplinary processes, and litigated matters in the Fair Work Commission. I hope you found all of this information valuable in your decision-making process, but if you have any questions about misconduct, dismissals, and workplace policies, please get in touch with the team at Williamson Barwick.